The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Three cases will be submitted this afternoon. These cases are Mary Jack and others versus Jennifer Booth, State of Iowa versus Darian Love, and State of Iowa versus Kendall Ware. The Ware case is submitted without argument at this time, and we'll now hear the arguments in the Jack case. Counsel?
Good afternoon. My name's Tom Shomaker. I'm a lawyer from Omaha. I represent Dr. Jennifer Booth in this litigation. I'm here to ask you to restore the jury verdict that we got a couple of years ago that was taken away by the Court of Appeals for two reasons. The first is the rationale that the Court of Appeals used in reversing the trial court is based on an erroneous reading of the cases that are cited, and I will go through those cases individually in a moment. The second reason is that the plaintiff's argument about some kind of cloak of good feelings that go on to for the benefit of a doctor who assists a juror in a fainting situation such as we have here is transferred to all of the healthcare providers who were in the courtroom. This is a case of the fainting juror, and assistance was rendered by one of the defendants, Dr. Sweetman. In a nutshell, the case was really two cases. Dr. Jennifer Booth, my client, is an obstetrician. She delivered a baby for Mrs. Jack by cesarean section. And after that cesarean section, there was bleeding. After a time, a hysterectomy was done by my client to stop the bleeding. The claim against her was that she didn't act quickly enough in the face of a medical emergency and let the patient bleed. If she would have acted faster, the thought was, then there wouldn't have been a need for a hysterectomy, and then the patient would have had the bleeding stopped more quickly. When the hysterectomy took place, that's another operation, and that's where the other defendant, who's no longer with us in this case, Dr. Sweetman, an anesthesiologist, got involved. Dr. Sweetman was there for the operation, and they had to anesthetize the patient so that they could remove her uterus, and he administered some fluids in the arm of the patient. Well, what happened was that arm got infiltrated, and it caused damage to the plaintiff. It was disfigurement, there were pain and suffering, medical bills, and the claim against Dr. Sweetman was you inappropriately administered anesthesia. The claim against my client was you failed to act quickly when a medical crisis presented itself, a bleeding patient, you should have acted more quickly. Okay, so we go to trial, and we're into the trial there for a while, and as you know, to get to the courtroom, right down the street there, if I'm pointing in the right direction, takes a lot of time and effort on everyone's part to work the case up and finally get our day in court, or our week in court, I guess it was. And sometime during that week, we're sailing along okay, and Dr. Booth, my client, is on the witness stand, at which point a juror faints, and it comes to our attention. One of the jurors waves his arms, and here's this juror sitting next to him who had fainted. Now at that point, here's what happened. Dr. Booth, on the witness stand, right next to the jury box, remained on the witness stand or stood up or something, but the record's clear, never really did anything more than observe. Dr. Sweetman, the other defendant, came from his position at the other side of the courtroom over into the jury box. Now, he's an anesthesiologist, and I think he's certainly capable of handling something like this, and he acted appropriately in a medical sense in administering aid. Well, now there's a big brouhaha. He's tending to the juror. We don't know exactly what's wrong, and there's a happy ending for the juror. She just fainted. Okay, Dr. Booth was describing the hysterectomy, And she got queasy, I guess, we found out in retrospect, and fainted, but nobody knew that at the time. Was she having a heart attack? What was going on? Who knows? But Dr. Sweetman was there. Well, Judge Stayskull recognized pretty closely on, and we don't have time stopwatches, and we don't have a transcript that gives us the exact time, and it was a jumbled moment, as you can see from the various times this was discussed in the record. Nobody knows exactly how this went down, but the judge removed all the rest of the jurors from the courtroom, allowed Dr. Sweetman and perhaps Dr. Booth, in the sense that she gave the patient a drink of water, to see if the patient, I keep saying patient, it's a juror / patient, make sure that that juror was okay. Well, the juror was okay and very nonplussed and embarrassed and everything that all this happened. But long story short, she was excused from service. Well, now this didn't sit too well with the plaintiff's attorney, because it looks like we have some heroic efforts undertaken by Dr. Sweetman. The jury gets to see that. Now we're on trial here and keep going. That's what happened. And he didn't like it. And he asked for a mistrial. And Mr. Updegraff, my friend here, stood up in court and asked for a mistrial, and we recounted what happened, and the record's very clear. It's Dr. Sweetman did this, Dr. Sweetman did that, ran in, did these things on behalf of the patient. Dr. Booth wasn't even mentioned in that motion for mistrial. I don't even know if there was a motion for mistrial regarding Dr. Booth at that time. It's only later on when we read the record, as things goes on, that Dr. Booth, the afterthought in this situation, is thrown in with, we need a new trial because Dr. Sweetman did something heroic. Oh, and by the way, Dr. Booth too, because she's another healthcare provider. Okay, we go on to jury verdict, we win, and there's an appeal. Motion for new trial shot down, and then we find these other cases, and I'm going to discuss some of them with you today. And some of them were discussed by the Court of Appeals, I think improperly.
Mr. Shomaker, let me ask you a quick question before you get on to the cases.
Yes, Justice Cady.
Did the juror that fainted, did she rejoin the jury for any period of time prior to the time she was dismissed?
I don't think so. I think the jurors were taken back, and then the other juror was kept there, and the judge individually polled the other jurors. Is this going to affect you? Is this a problem? And when you read the language about that, it's all about Dr. Sweetman. What Dr. Sweetman did, does that bother you? And Mr. Updegraff and myself were allowed to ask questions of each individual juror too. And Mr. Updegraff asked only about Dr. Sweetman. What Dr. Sweetman did that bother you? Did that bother you? And I didn't ask anything. Okay, and this is going to be one of my points, that if one doctor is heroic, the other doctor does nothing, then why does this heroism, which we attach to the hero, slop over to the one who doesn't do anything? That's argument number 2 for me, if you'll consider it. Does that answer your question? And I don't want to mislead the court about the state of the record. I was a witness to that. I even filed an affidavit. But some of this is unclear because it's like that psychology experiment when, as I pointed out, and this is what I learned, one thing I did learn in college, 300 kids in a psychology class are sitting there, and the teacher stages a robbery or a murder, and it's all set up, but the kids don't know it. So somebody runs in, shoots, scream, yell, everybody runs out, and then they stop and they go, okay, this is just write down what you saw to the 300 people. And I'm not saying there are 300 different versions, but there's more than one. There's a lot of different versions of the facts.
It's your position. I mean, I may move over to argument number 2 because either one is, in your view, dispositive. It's your view we could reverse the Court of Appeals as to your client and leave the Court of Appeals decision in place as to Dr. Sweetman.
Yes, that's
trial.
my position. And the court has that power. It's really no different, I don't think, than a directed verdict in a medical malpractice case for some defendant. And I've been there a few times on the good side and the bad side of that, where we leave and there's 6 defendants, and then we come back and there's 4 defendants. And nothing is said other than we're just going to keep going. Or how about a settlement of a case in the middle of the trial? That's also been something that's happened in my experience. Where
I have a simple question. Did Sweetman ask for further review?
No.
So we can only affect your not Sweetman's then.
Well, I don't want to argue for Dr. Sweetman, but in the thing that they filed, they said you do have that power. I don't want to go there because I don't represent Dr. Sweetman, and frankly, I'm trying to draw a line between.
But
my
they haven't
client-
asked for us any relief from the Court of Appeals opinion, have they?
No, no, they did not. And again, I could discuss that, but I'm not here for Dr. Sweetman. And it's to the benefit of my client to try and draw this line between him and her, because that's what's so unique about this case. That second point, I'll take it up first. The plaintiffs are saying you got to give a new trial to both defendants, because when you see heroism, like such as we saw Dr. Sweetman, or at least doing his duty, but something affirmative that is a positive medical thing, he responded to an emergency, he went in, he did what he could for that juror. You just can't ever get over that. And that's what the whole line of these cases pretty much stands for, I think. That says you got to have a new trial when that happens. You can't wash it away. The juror can't get that out of their mind, okay? And I'm going to concede, okay, fine, okay? Let's say that's right. But why does that heroism, the cloak of being a hero, apply to someone who not only doesn't do anything, but who's on trial for not doing something in a medical emergency, and who the jury observes in a medical emergency not doing anything? If anybody's got the right to make a motion for mistrial at that point, it's me. And to prove that one, I will quote my friend, Mr. Updegraff, who said the following when that occurred. If she'd passed out and Dr. Sweetman had done nothing, this is right when this was all happening in the record on the motion for mistrial. If she'd passed out and Dr. Sweetman had done nothing, which I'm glad, then the defendants would be in a situation where they would be evaluating whether or not that prejudices their case. So point number 2, in a nutshell, is you can't give a goodie to the plaintiff for my client for not doing anything if you're going to give him a goodie for Dr. Sweetman doing what he did. Dr. Sweetman has colored the jury by his actions, and the plaintiffs say that's unfair to them. But that you can't say that applies to Dr. Booth under these circumstances. It just doesn't. It just doesn't make any sense.
And what's our standard of review of Judge Skasel? It's abuse of discretion, right?
Abuse of discretion. He abused his discretion by not ordering a mistrial or a new trial.
What about the argument that the defendants in this matter are so intertwined with each other and it all sort of arises out of the same set of facts? I understand there's discrete allegations of malpractice against each one of them, but that they're really, really intertwined, and it would be unfair to separate those out.
I'd make that same argument if I was Mr. Updegraff, but I think you can distinguish that because there are really 2 cases here. It's a little different than some medical malpractice cases. We have discrete acts by 2 different people. And I go back to the directed verdict thing or the settlement thing. You got the power to do that. You know, it's a lot of work to go through these trials. And there's got to be a reason if you're going to take away a jury verdict. You know, we thought we had a very strong case. Now, I can't believe I'm running out of time because I thought I'd be up here for about a minute and then be hemming and hawing. But let me get to the first point. The Court of Appeals reversed this for the wrong reasons. They said, you know, this court has an authority to grant a new trial as to some but not all. But we believe that these 3 cases, Rome, Haidt, and Hulkendahl, provide us with the proper guidance under the rare circumstances we have in this appeal, and they misconstrue every one of those cases. They said in the Rome case, it was a medical malpractice case against a hospital and 2 doctors. The stricken juror was administered aid by only one of the defendant doctors. That's not right. If you read it, there's Dr. Bang and Dr. Lee. Dr. Lee's pounding on the chest. Dr. Bang, stethoscope in hand, assisted. So they got that wrong. Then in the case of Haidt, that's a medical malpractice action against a doctor in a clinic. A new trial was ordered with respect to both clinics, as if to say, well, see, you got to give a trial to everybody if you're one of them. This is a clinic, okay? A clinic isn't doing anything. The clinic just exists as the employer of this doctor. And the last case, Hawkadahl, medical malpractice action, if you read that, you may see some other doctors' names in the caption, but I don't know whether they were dismissed out or what happened. When you read that case and the subsequent appeal from that, nowhere is there anything but the two doctors that rendered care. So, in a nutshell, if one doctor does nothing and another doctor does something, they should be treated differently is what I'm asking. You know, it's got to be a lot there for the plaintiff to reverse a jury verdict if we're going to use abuse of discretion as a guideline. And that's what we have to do. And I'm not even going there about Judge Stayskull's finding that, you know, he thought everything was okay under the circumstances. I'm even conceding the plaintiff's point on the idea that if a doctor does something to a fainting juror, that's a new trial. But only as to that doctor. That's what I'm urging you to consider.
Thank you, Mr. Shomaker. Mr. Updegraff.
May it please the court, opposing counsel. I think in this appeal, it is important to understand what we're really talking about here. The real issue isn't whether or not prejudice occurred to these jurors, because the rules of civil procedure, the rules of evidence, prevent us from taking depositions of these individuals, of talking to them and saying whether or not they were prejudiced. The issue in this is about protecting the legal process. The issue has to do with the possibility of prejudice, creating an appearance that there isn't a fair trial.
I mean, where we can't evaluate prejudice, then don't we have to defer to some extent to the trial judge? Because he's the other person who's there, who has the objective view of the scene and sat through all the events. And he saw, I mean, very clearly, it seems, as to Dr. Booth, that this was not an event that affected the fairness of the verdict as to her.
I guess I understand your point, but the point of the matter is that it's the gravity of the potential prejudice that I think is important here. The idea being is that what all of these cases talk about is that if you talk to the jurors and you sit there and say, well, can you be a fair and reasonable person? Those jurors may not be able to be completely honest with you because they can't be completely honest with themselves. And I'm not trying to suggest that they're liars. What I mean is if you ask anybody, if you ask the majority of people in the world, are you a fair and reasonable person, and can you be fair and reasonable in the circumstances, they're going to say yes.
I understand that, but Judge Stayskull didn't just rely on that. He didn't just rely on the fact that he interviewed the jurors afterwards, and I take your point. How do you answer the argument that, you know, if there was prejudice, it would have been prejudice in favor of Dr. Sweetman and would not really have impacted Dr. Booth?
Well, that's what I'm talking about in terms of the possibility of prejudice. Is the idea is that I don't believe that you can actually ever come to a conclusion 100% for sure that anybody was prejudiced here. The problem is that when you allow something that creates the potential for prejudice, you then affect the underlying system, the very foundation of what our system's built on, which is that people who go into a trial believe that they're going to get a fair shake. The idea being this is that, you know, Mr. Shomaker says, well, it wouldn't slop over, and there's this cloak of goodness. The examples I come up with in my head when I talk about that is, could Dr. Booth hire somebody to come demonstrate a heroic act by another doctor in the middle of her trial? Could Dr. Booth talk in the trial and give evidence about all the times that she's saved somebody's lives in Mary Jack's trial? That's what Dr. Sweetman's acts imply to the jury, that doctors are important to our society. What we're talking about is, if you ask people what they want their children to grow up to be, number one answer, you play the Family Feud with it, number one answer is going to be doctor.
Well,
Didn't you have a physician testify as an expert in your case in chief against Dr. Booth?
Yes.
So wouldn't the jury have been favorably disposed to that physician as well?
Well, that's why I'm talking to you about the concept of, you get into a real problem when you have something that is kind of a bombshell and has the ability to create a great deal of prejudice. It puts everybody at a disadvantage to try and figure out whether that prejudice occurred. The importance is to understand that it could have occurred, and it creates a perception to one of the litigants that it did occur. That's the issue. Our job here Our job as lawyers and judges and in this whole system is to maintain an appearance of fairness to people so that they believe in the decisions that we render.
Counsel, would you agree, though, that Dr. Sweetman and Dr. Booth are in different positions?
In terms of the facts of their case,
Well, in terms of one was the hero and the other sat there.
I wouldn't agree with that 100% because of the facts of what was going on there. The deal, you have to understand.
How are they different? How, or why aren't they in two different situations?
I don't think they're completely different for one important factor. You have to understand the layout of Judge Stakel's courtroom there in Polk County. When you're a witness in that particular courtroom, you sit at a witness stand right next to the jury. So she's sitting right here, and there's a long bar between her and the jury. On top of that, in order to testify at that stand, there's no witness stand there. There's just a chair in the open. So what you have to do is you take a board and you put it in front of the witness and you set the papers on there. So from that particular scenario, Dr. Booth is actually barred from getting up. She's got to move 3 or 4 things. Dr. Sweetman is sitting in the gallery with a clear path to the jury. The point of the matter is he just got there first. So if you're talking about did she get some sort of disadvantage of it, that's a possibility. Was she disadvantaged by the fact that Dr. Sweetman got there first? That's a possibility. It's also possible that the jury felt that, boy, isn't it important we have doctors. Because the thing about it...
Let me probe this a little further, because everything you're telling me now is a reminder of the advantage the district court judge has. He's there. He knows the courtroom. We're hearing this from you, which is helpful. But we have broad trial court discretion for a reason. They're on the scene. So why should we take away a jury verdict that the trial judge thought should remain in place?
And it's certainly a very good question. That's what happened in each of these 3 cases that I cited to the Court of Appeals. As they said, even if the judge is on the scene, the judge can't fathom or can't properly analyze that because the effect that it would have on potential jurors is often in their subconscious. The jurors won't answer. The jurors will think they can get over it. It's such a stark reminder of the importance of doctors in our society that it would clearly create prejudice. And Mr. Shomaker wants to argue there's another possibility, and sure, there's other possibilities. There are always possibilities.
Counsel, aren't all 3 of those cases different in that they involve doctors? The defendant doctors were the heroes. There wasn't a bystander defendant doctor like we have here.
I agree with you. I think this is a unique question of law. I think that's why why this court granted an application for further review. I don't doubt for a second that's why I'm standing here talking to you about it. The question is whether or not that prejudice inures to everyone named doctor in the courtroom. And if you believe that it does, then I believe that those cases, and I believe that's what the Court of Appeals is saying in the passage that Mr. Shomaker quoted to you, is that the guidance from those cases carries over to anybody else who is a medical professional sitting in the courtroom and is on trial for failing to do something.
Was this this area discussed on voir dire? Did you ask the jurors about their preconceived biases or prejudice towards doctors?
What I asked them was, do you think you could be fair and reasonable to my client in this case? And I think Mr. Shomaker's point, I think, is nitpicking. He's trying to say, well, you didn't make a motion for new trial against Dr. Booth. You just made one against Dr. Sweetman. Well, I think implied in my statements about what Dr. Sweetman is the idea, and I think that's the same implication that the Court of Appeals took in this particular case. That
you're trying to say that Dr. Booth ought to be yoked in with Dr. Sweetman because all jurors have this understanding or implied prejudice for doctors and the heroic acts of doctors, and when parents want their kids to grow up to be doctors. And so I'm asking you if this was a concern of yours. Was it an issue that was tackled during jury selection?
I think it's implied in the questions I asked, Your Honor. I do believe it was tackled. Did I specifically say Dr. Booth?
You were satisfied that you had jurors that were understanding enough not to bring their prejudices into the courtroom?
I mean, I guess maybe I'm misunderstanding your question, but I think if I ask jurors those questions in voir dire and say, do you believe that doctors are heroes? I don't remember if I asked that or not. It's been 2 years. I don't believe the voir dire was reported. If it was, I haven't read it here, coming here today. But the point of the matter is that point was made very clear to all of us sitting there. Mr. Shomaker refers to this as the case of the fainting juror, and he does concede that we didn't know at the time the juror fainted what the situation is. I'll tell you what my perspective was. I'm sitting there cross-examining one of the defendants, and one of the jurors raises their hand, and my first thought is, well, here we go. Something's going to go wrong. I look at the juror next to him, and that juror is completely limp. I don't know if that juror's dead or not. I'm guessing that they're not, but I can tell you my heart started racing, and I started thinking that. And when I think about this case, I think, thank God I was in a medical malpractice case. I could have a juror faint in a car accident case. I could have a juror faint in a different case. There happens to be 2 qualified professionals sitting in the courtroom to take care of it. It was, to say it was a brouhaha or a hubbub or whatnot is an understatement. Legitimately, this person could have died in front of me, and we happen to have somebody there. Did it all work out? Yes. But that's in the viewpoint of 20/20 hindsight. For everybody sitting in that courtroom, for every one of those jurors, they had the experience that I had, or at least we can assume that they did, and I think that's what the Court of Appeals in these other cases did, of, oh my God, what happened to this person? And then you have the classic, is there a doctor in the house call? We just happen to have some. I got to tell you, Dr. Sweetman, I have never criticized him for going into the jury box in this case, and I never will, because it was absolutely 100% the right thing to do. And I don't know if Dr. Sweetman knew that he was going to be creating this issue for mistrial or not, but it didn't enter his mind, because he knew what his responsibility was, and he got in that juror box right away. And that reminded everybody in that courtroom why we love doctors. That's what it is. And from that perspective, I think that inures to everybody. I think that's what the Court of Appeals is saying here, is they are saying you cannot separate Dr. Booth from the title doctor. You can say, well, she didn't do what she was supposed to. It's not like she did nothing. I mean, it's...
The whole idea of your case is to separate. I mean, and the whole thing we try and do in the legal system is not to treat people as groups, but as individuals. I mean, and the whole point of your case, I mean, you bring in an expert who presumably told the jury, Dr. Booth is not like other doctors. She fell below the standard of care. And now what you're coming in here is arguing that, well, no, the jury, notwithstanding all of that, and notwithstanding the effort to get a jury that would treat everybody as an individual under the eyes of the law, they're just going to treat all doctors the same. They see one doing a generous, noble thing, they're going to transfer that to the other. Isn't that kind of your position?
I would respectfully disagree with you. My position is that I wanted to try that case on the facts of that particular case. I'm not in the business of trying to say that doctors are bad people, that Dr. Booth is a bad person. I'm in the business of saying in this particular circumstance she fell below the standard of care. What happened in that courtroom is that everybody got a reminder that she's part of a group, that this emergency situation created a reminder to everybody that she's part of a group that does good work in our society.
Okay, and then not only did you have an opportunity, of course, on jury selection, but the trial court also gave you an opportunity after this incident to question the jurors about their biases over what they've just witnessed. Why isn't that enough a remedy for you to ensure that you were given a fair trial?
I think for the same reasons that are discussed in the other 3 cases that dealt with this. I understand you want to draw a line between the 2 of them, but the point of the matter is in each of the cases that the Court of Appeals relied upon and I supplied to them, the district court judge, in some circumstances, didn't offer the idea of voir direing the witnesses or the jury anyway, polling the jury. To be fair, that was my idea. I'm the one who suggested it. But from that particular circumstance, each of these courts have said is when this type of anomaly occurs, that there isn't anything that the district court judge could do to restore fairness. That in that particular circumstance...
But what is we're looking at this from an abuse of discretion standpoint, and I consider that to be a very high standard,
Sure.
as we talked about earlier. So what was the real abuse of discretion here? Are you saying it was an error at law to make this determination then based upon those 3 cases?
That is exactly what, I mean, those 3 cases are essentially us looking for every case that we could find on this issue. And the 3 times that other appellate courts have looked at it, they each said this is an abuse of discretion. The district court said, we can give a fair trial, let's give a verdict. And each of the courts said, that's an abuse of discretion. And they don't, it's not and the thing is you have to understand the abuse of discretion standard, and I think this is part of what goes into Judge Stacel's thinking, is the abuse of discretion standard comes, it's a loaded term. It comes with a negative connotation that the trial judge has done something wrong. I want to make it clear, I don't have any criticism of Judge Stacle. I think Judge Stacle is a very good judge. I think he did his best in this circumstance. But what each of these courts has said is that under these circumstances, no judge's best is going to remove the perception that this process isn't fair.
But isn't he still in the best position to determine whether the integrity of the entire trial has been compromised by this incident? You know, and I'm not minimizing this, and I'm sure it was a very, very important and significant event, but we are talking about a trial that I assume lasted about a week, with all sorts of information and testimony coming in before this incident, all sorts of testimony and argument after this, and exhibits, you know, both pro and con to the case. And we are talking about, you know, a relatively small portion of this trial, which he handles in the way that it sounds like you would agree he should have handled it. He just doesn't rule in the way that you want him to, and the way these other cases, and obviously the Court of Appeals said. But is that still an abuse of discretion just because we disagree?
What you're saying, and I understand what you're saying, but inherent in the concept, and I've run out of time, I'll answer your question by your leave. But the point of the matter is this. I believe that every judge who does this job is doing their best to do this job, and that they believe that they can provide a fair trial. And I think that why I mentioned that the abuse of discretion and the new, and included that the concept of having to grant a new trial are in fact concepts that a lot of judges take personally, that it's a concept that they have failed in some way. And so your position that Judge Stacegill is in the best position to review this is correct. But at the same time, the reason we have an abuse of discretion to standard, so we can look at it, is that there is an acknowledgement that in some circumstances, even the judge can be biased in these circumstances, because the asking for a new trial and the abuse of discretion standard that goes with it, for somebody to question that can be perceived as an attack on the judge or an attack on that judge's methods. And in this circumstance, my belief is the unforeseeable happened. There was nothing that Judge Stacegill could do to prevent it, and there was very little he could do to essentially remove that prejudice after it had occurred. So thank you very much.
Thank you as well, Mr. Updegraff. Rebuttal, Mr. Shomaker?
Thank you, Your Honor. I just made a couple notes, try and do rebuttal and not repeat myself. I guess we're conceding, if it makes Eric Updegraff feel better, that when you ask a juror, can you be fair and impartial after they've seen something like this, and they say, yes, I can, maybe they really can't. I mean, maybe that just puts a psychological imprint on them. I guess I'll concede it, but it doesn't fit this case, okay? Why is the psychological imprint for the doctor that does something transferred over to the doctor who does nothing? That was my point I was probably inartfully trying to make. As long as we're going into evidence that isn't before the court or the layout of the courtroom there, I think it was pointed out that Judge Stacegill would have taken that into account. But my recollection was Dr. Booth is right here. There's the jury. Dr. Sweetman was at the farthest seat in the farthest counsel table over there, and he's over there right now. He responded. And I don't think there's any question, if you read the record and the way that we've revisited this over and over again in the matters that make up the record of this case, that that's what happened. He's there. He went in. Dr. Booth did not. I'd like to make this point. Mr. Updegraff says this was his cloak of good feelings in the appellate pleadings. Now it's doctors are important to society. So because Dr. Sweetman is a doctor and he's important to society, when he does something good, then all doctors get that benefit. Okay, what are we going to do when we have a medical malpractice trial down there and some doctor's walking down the hallway for some other to pay a parking ticket, and he sees something in the courtroom and runs in there and renders aid to a jury? Case over, because a doctor has rendered aid to a juror, which now slops over to the defendant doctor in that case. What if the plaintiff's or the jurors watched a television show last night of Marcus Welby or Ben Casey or some kind of thing, and a heroic doctor, or all the Ebola doctors that do this magnificent work that have just won the Time Man of the Year award. You just can't possibly get away from that, and it's just you can't find against a doctor. Well, I know from my personal experience, yes, the jurors can find against doctors, if the evidence is there. So let's give the jurors some credit, and let's avoid getting to these extreme positions, because I think that's would have to be the bright line rule. If you make it, is going to be, if a juror faints, trial over. Because either somebody did something, it's heroism, somebody didn't do anything, that's prejudicial. A couple more little points. I didn't mean to be nitpicking to Mr. Updegraff about when he made the motion for mistrial and didn't mention Dr. Booth. I'm trying to point out that her non-involvement is what I was trying to underline by that. And if that's nitpicking, then I'm guilty. But the record kind of shows that there's just very little Booth and a whole lot of Sweetman in the record about what happened in this case. And would you please read those 3 cases that the Court of Appeals cites? This is what was my first argument till we switched that one around, because I think it's important. If we're going to go down here, if there's going to be a new trial as to Dr. Booth, I think it's based on specious reasoning. I think that the Court of Appeals set up 3 cases and said that they say something that they don't say. They say that those cases are examples of one doctor helping, another doctor not helping, everybody gets a new trial. That is not what they say. And if you read them, I think you will agree. If I'm wrong, then hold it against me. But I don't think that that's correct, and I think that it's one of the reasons we brought this thing up before you is we don't think that the Court of Appeals got that one right. And because they said what they said, we wanted to have an airing about what is really happening there.
I realize you're representing Dr. Booth, not Dr. Sweetman, but there is going to be a trial, a retrial against Dr. Sweetman.
Correct.
No good deed goes unpunished. He has to repeat a week-long trial. At that trial, is Dr. Booth's alleged negligence irrelevant, since it only
I guess it would be if
concerns-
she's a defendant. I hadn't thought that one out, because there is a theory that Dr. Booth, if she was negligent, then whether Dr. Sweetman was negligent or not, she'd still be responsible because a second operation had to take place. I thought you were going to ask me that one. But, and I would have said I'm intrepidly making my point in spite of that. I don't know. I know he'll be on trial for medical malpractice, and I would think that that would be it, for infiltrating the arm. So,
Well, plaintiff's not prejudiced at trial number 2 against Sweet only because they don't have a line on the verdict form for the fault of Dr. Booth, correct?
yeah, but she won a jury trial, I mean, geez, we get something for that, don't we? That's what I'm asking you to keep in place. And I'm not saying that's a fallback position for the plaintiffs, but the fact is they're going to have an opportunity to continue the case against Dr. Sweetman for what they said was malpractice the first time around. But I'm not here about that. It's just about Dr. Booth. And I'll just give you I guess I'm over. Litigants are entitled to a fair trial, not a perfect trial. I also remember that one for law school. I thank you for your consideration. Are there any other questions?
Thank you as well, Mr.
Thank you very much.
Mr. Shomaker. The case is submitted, and we'll now hear the arguments in State of Iowa versus Love.